Verdict Vantage, covering breaking news stories. Thank you for supporting our research. We would like to extend a trigger warning before we continue. Please be advised.
This video contains discussions about true crime, which may include topics such as violence, assault, and other distressing incidents. Viewer discretion is advised.
Verdict Vantage, thanks you for tuning in. Your support means the world to our channel. If you enjoyed this video, be sure to give it a thumbs up, leave a comment sharing your thoughts, and hit the subscribe button to join our amazing community. Stay in the loop on future updates by ringing the notification bell. And if you found this valuable, sharing is caring. Thanks again for being here.
All right, let's go ahead and call up Miss Boone's case.
State of Florida versus Sarah Boone, 2020 CF 2603. State of Florida.
Deputy Conjecture on behalf of the state.
Defense.
Frank Bankowitz.
Let's go ahead and swear Miss Boone in.
May you please raise your right hand to be sworn in? Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Morning, ma'am. Tell me your name and your date of birth.
Sarah Boone, October 10th, 1977.
All right, we're here for pretrial conference today. Mr. Cacciatore, where do you stand in preparing to proceed forward to trial?
State's ready, Your Honor.
Mr. Bankwitz, where do you stand in regards to preparing for
The
trial?
defense is not ready. We're requesting a continuance. we are having difficult time finding an expert who's willing to work for the JAC rates. And so I'm still it's an essential part of the case, basically. It's never been initiated before by any of the prior attorneys that I'm aware of.
In broad terms, what's the nature, what's the field?
Spouse defense.
Okay.
Statutorily, we have to give the state notice, sufficient time, and name of the expert and the essential elements that they'll be testifying to.
Okay. Mr. Cacciatore, what's your position in regard to the defense request for continuance?
I don't want to rinse my detergent jugs before recycling them, so here's what I do instead. Did you know you're supposed
I would have no objection to another role.
So, Mr. Bankwitz, how deeply have you plumbed the depths of the pool of experts in this field to find out or find one who's willing to work for the JAC rate?
Well, I've actually talked to 3, and but they don't have contracts with JAC and are not willing to work with JAC. And I've made some other inroads with battered women's shelters, trying to get their psychologists, who'd be willing. Problem is willing to testify, basically.
Okay. Because of the concern about the compensation rate for testimony?
Well, that's one of the things. And to be honest with you, this case has had so much notoriety that people don't want to be involved.
Okay. So, Mr. Bankwitz, I'm certainly willing to give you additional time based on my understanding of the case. I understand why that would be a defense the defense would want to explore about potentially presenting. What I'm not sure about is whether the inability to find an expert forever delays the trial of the case.
I wouldn't expect it to be a forever delay, Judge. And you know me better than that.
Mr. Cacciatore, well, I just want to make sure everyone in the room understood that, I'll give reasonable amounts of time to prepare a defense. The defendant's entitled to an adequate defense, but they're not necessarily entitled to the exact defense they would prefer to have if resources were unlimited. So, Mr. Cacciatore, remind me, where are we as far as lining up your various homicide cases for trial? I know we have some things set to go to trial in the June trial period.
Yes, we have both Mr. Herlong and Mr. Sowell set for then. And then as far as this trial period, we have Mr. Hall and potentially Mr. Ofori as well. If I could ask of the defense, because I think it would make a difference in the timing of the continuance in this case, does the defense intend to hire an expert to testify generally as to the precepts and the things that go along with battered spouse syndrome, or do they intend to hire an expert that will evaluate Mrs. Boone and want to comment on her directly? And the reason I ask that is because I think the case law is clear that if it's the latter thing, then the state is entitled to have her sit down with our own expert to be evaluated as well. So that would obviously take more time if that is going to be the path they're going to go.
Mr. Bankwitz, are you in a position to distinguish?
Number two is definitely what we're looking at, Judge. Although number one would be incorporated in that.
So here's what I am, and Mr. Cashflow, let me ask you this. Let's say that turns out not to be an issue. We're not going to have 2 experts. How long would it otherwise take you to present your case? Just rough idea.
I would say 3 days.
And other than this potential defense, Mr. Bankwitz, and is that including jury selection, Mr. Cacciatore?
No, well, I probably 3.5 days with jury selection.
All right. And Mr. Bankiewicz, other than this potential defense, if we picked a jury in 1 day, the state presented their case in 2.5 days, how long do you anticipate a defense presentation would be at this point?
I'd say at least 3 days.
Okay. So here's what I'm thinking. I'll grant the continuance. I'm thinking continuing out to the July 11th pretrial, July 24th trial period.
How long is that trial period, Judge? I have a time-certain death penalty case in Lake County starting the second week in August.
That's a 3-week trial period, so it'd be the week starting Monday, July 24th, Monday, July 31st, and then the last week of the trial period would be Monday, August 7th.
That's when I'm scheduled to start picking a jury in Lake County.
Well, let's do this. I want to set it for that date. That way you'll have a much better idea of what's actually happening on your death penalty case in Lake County. I understand that they're priority cases, but I also know that they're the cases where if a problem comes up, no matter what a judge has said before, they're likely to allow the case to move because they don't want to try it twice.
Just to advise the court, this case had to be continued at the last minute because of one of the attorney's wives basically had a stroke. And so it was a week before we were scheduled to start in that case. But Judge Davis up there, now that has, I won't say resolved itself, but is in a better position. Judge Davis has advised all of us that we're going, quote, come hell or high water.
See, I try not to say things like that because I feel like I'm just tempting fate.
Well, that's just Lake County, Judge. What do you expect?
Well, having never worked there, it means nothing to me. So, I'll grant the change, July 11th pretrial, July 24th trial period. And let's go ahead and do this. While I'm giving July 11th as the date, let's go ahead and have the lawyers reach out to my judicial assistant and just like we did this time, schedule
a status
separate, unique date for pretrial so that I have, y'all have my undivided attention when we talk about the case. I don't have 97 other lawyers tapping their fingers waiting to get to me.
Sounds good, Judge.
Okay.
Thank you, sir.
All right. Ms. Boone, we return to the Orange County Jail pending further order of the court. And Mr. Bankiewicz, you can electronically file the motion to continue.
Yes, sir, we will.
And the court minutes will say it's granted. All right.
Thank you, Judge.
Have a good day.
You too.
And this is me in my 60s. How?
We're getting a closer look inside the mind of Sarah Boone, the woman accused of murdering her boyfriend by zipping him up into a suitcase. In another series of handwritten letters sent from jail, Boone calls out her defense attorney, arguing she hasn't heard from him in months as her case inches closer to trial. She also sends a message to the presiding judge saying, quote, "My case has turned into an unnecessary witch hunt," and later asks, quote, "What's your cut?"
For everything you've done to me.
Sarah.
For everything you've done to me.
Sarah.
F*** you.
Sarah.
F*** you.
Sarah.
Stupid.
Sarah.
That's my name. Don't wear it up.
Florida prosecutors say the 44-year-old murdered her boyfriend, 42-year-old Jorge Torres Jr., in February 2020 by putting him in a suitcase and leaving him there to die. At the time, Boone told investigators she and Torres had been drinking and playing a game of hide and seek. After that, Boone says she went to sleep and woke up hours later when her phone rang. That's when she says she found Torres unresponsive. Officials say Torres was zipped inside the suitcase for hours. Shocking cell phone video was later released showing Boone speaking to Torres while he was inside that suitcase. As Law & Crime Network previously reported, Boone sent multiple handwritten letters to her court-appointed defense attorney Frank Bankowitz, asking for a clearer path of communication. In a story Law & Crime Network posted in March, Boone wrote, quote, "I've exhausted my resources and am again just sitting here waiting for you to contact me in whatever way you are able and as soon as possible, please." At the time, we noted the letter was seemingly missing a sentence or possibly even pages. In one of Boone's most recent letters, dated April 6th, she seemingly references the missing pages and a report, writing in part, quote, "The enclosed letter I sent, 3/22/23, was scanned incorrectly on the clerk's website, only the first and third page, so I am resending with nothing on the backs to avoid confusion, and were missed previously. Thank you for reading my entire letter and uploading correctly for all the world to read. Also critique and judge wrongly and incorrectly as usual. Ignorance is bliss." Boone goes on to write, quote, "I wonder what platform of popularity I will be featured on next, and how much wasted time, effort, and thought will be put into mutating and grossly exaggerating my case information, racketeered to the World Wide Web. SMH or shaking my head." She ends that portion of the letter saying, "Shout out to my supporters," with a heart drawn next to it. She signs the letter hopeful no matter what. In Boone's most recent letter, dated May 15th, she addresses both the case's judge, Wayne C. Wooten, and attorney Frank Bankowitz. She writes to Judge Wooten in part, quote, "My truth needs to be heard, and it is my right. Do not give me rights expecting me not to fully utilize them. I voted for the president and governor while here in jail, and stop violating what I've been trying to utilize or less the value of my capabilities and opportunities. I am not apologetic in any way for being an observant, hardworking, above average, non-stereotypical inmate. I can only imagine sadly how others not as outspoken as myself have been and are being mistreated, overlooked, and dehumanized." She writes in all caps, "Get it together." She continues, quote, "When I've tried to voice my legitimate concerns to you in the courtroom, 5 times total in 3.3 years, and in my letters to, quote, save it for my next attorney if told anything at all. Do tell your honor, which attorney?" According to the letter, Boone's representation has switched 6 times for both irreconcilable differences between the attorney and client and conflicts of interest. In this portion of the letter, she writes out a list of statistics for Judge Wooten, pointing out court-appointed attorney Frank Bankowitz has answered 0 of her phone calls over more than 7,000 hours of representation. Boone later writes, quote, "Are you allowing/enabling my constitutional rights to be continuously violated?" Boone then writes out what she calls a history lesson for everyone, referencing amendments she feels are appropriate to highlight. She continues, quote, "Why are you allowing numerous case safety and protection elements to be breached, violated, manipulated? Why has a gag order never been implemented? My case has turned into an unnecessary witch hunt from the innumerable violations of my case details being leaked and racketeering illegally in exchange for website hits, viewer ratings, etc. in exchange for," and she writes 3 money symbols. "What is your cut, Your Honor?" It's not even about the suitcase anymore. My case is now a global event with the video receiving over 3 million hits depending on the website, in turn making me realize that's over 3 million less unprejudiced, unbiased, non-discriminatory, fair jurors I will have access to on my case. How is that going to work? Now what? Boone then addresses Bankowitz, saying their last meeting was February 15th. She writes to Bankowitz in part, quote, "Please see from my perspective the botched, eye-rolling experience I'm going through still, and how I believe anyone would act or do if in my slides doing the same. What would you do? Do not fault me in trying to make the best, most successful outcome possible for myself in every aspect in the convoluted predicament I am in and have been in over the last 3.3 years. I would rather be called a narcissist, pain in the explicative, arrogant, strange, or whatever else anyone wants to waste their time to think of. Just don't call me a murderer, which I am not." No one knows me except for the ludicrous insanity that's been made up, mocked, edited, and spewed all over the internet. It's not me. Boone is due back in court on July 11th for a pretrial hearing. Right now, her case is expected to go to trial on July 24th. Reporting for Long Crime Network, I'm Sarah Gillespie.
Two years ago in Winter Park, Florida, George Torres was zipped into a suitcase by his girlfriend. Why Sarah Boone did that? She says it was a game of hide and seek, but she's going to have to tell that to a jury. Because she whipped out her phone afterwards and videotaped him begging for his life as he slowly suffocated. Up until now, his parents have not spoken, his family has not spoken, but tonight they are. I'm joined by the reporter who got that interview for us, News Nation national correspondent Alex Capriello. He joins me live. That trial is coming up July 4th, and you are hearing exclusively from the parents. What did they tell you about what they know about the case?
Yeah, it really dawned on me, Ashley, that there's been so much attention on Sarah Boone, so much focus on the bizarreness of this trial that perhaps no one has ever really taken time to speak to the Torres family. And it turns out my suspicions were correct. Within the 3 years since Sarah was arrested, they haven't spoken to any national or local media outlets, had the chance to say their side of the story. So we sat down at their kitchen table and they really just opened up to me all about who George was, what he meant to their family, and also, of course, his relationship with Sarah, which, by the way, they never approved of. But interestingly, Ashley, George's mother tells me that she has a great deal of sympathy for Sarah because if she is convicted, she'll never have the opportunity to raise her son like she did with her many children. Take a listen.
He was a good son. He wasn't perfect, but he was a good son. And every time that he come here, every time, he just stand in that wall and he said, Mom, I love you. Mom, I love you. I said, I love you, love you. And they come and give me a hug. And they, look at his father and he said, Pop, you're my hero. You're my hero. He was a father. He was my son. He was an uncle. He was a cousin. And he was a friend. I was a nephew. She don't kill only my son. I feel sad for her. I don't feel sorry. I feel sad. And I don't hate her. Really, I don't. I don't have that in my heart. I never hate nobody.
Gosh, so powerful to sit there with her as she explained more about her son. Interestingly, she said that she's never seen that cell phone video that shows George locked up in that briefcase, or I'm sorry, that suitcase. She says she has no intention of seeing it, but she will be there at the trial seeking justice.
It's going to play at the trial. I hope they give her a big advance warning because it is hard for us to watch it. I can't imagine a mother hearing her son begging like that. You also spoke with George's brother, Ezekiel Torres. It was off camera. What does he think about what happened?
Yeah, it was really a struggle for Ezekiel to talk about his older brother, George, because for so long during this relationship between George and Sarah, the family just disapproved of it. They disapproved of Sarah. And so Ezekiel told me that when he saw Sarah and George walking toward him, he'd turn his back and walk away. And that now has led to an immense amount of regret that he has, that he didn't have a chance to actually say goodbye to his brother. So he's certainly going to be at that trial. He wants to see a guilty conviction come down because he sees that as the only way that his brother and his family, who are just so heartbroken, can get justice.
Alex Capriello, a fantastic exclusive interview. Congratulations for landing that, and thank you for bringing it to us. I appreciate it. Alex Capriello reporting live for us tonight. Thank you for watching. Go to News Nation now.
Let's take you to Florida right now for an update on the suitcase murder trial. Sarah Boone's case just called by the judge. Let's go in together live.
Sarah Boone, 2020 CF 2603. Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Good morning, ma'am. Tell me your name and your date of birth.
Sarah Boone, 10/10/77.
All right, we're here for a status hearing on your case. Your case was set for pretrial conference back on July 12th, but as I promised you, I was going to bring you over, so whatever the things that we normally discuss at pretrial would be discussed while you were present in the courtroom. Mr. Banquets, in court, you previously discussed an issue with getting JAC to pay your expert, I'm going to just paraphrase, for the battered spouse defense.
And they have filed a formal objection, which now has been set for hearing. I want to say September the 18th is the first available time, because they have to have, they require 20 days for hearing purposes, and we couldn't get on your docket before that date.
So, Mr. Cacciatore, Ms. Boone's present. Mr. Banquets is asking to continue the case so that he can, we're going to have a hearing with JAC on his request for funding for a defense expert. Given my understanding of the case, that defense expert would be crucial to at least one defense that's going to be offered in case. And my understanding is you can't do anything until that expert actually is identified as a witness who's going to be called, correct?
That's correct.
She has been identified.
I understand, but it's not unknown at this point whether she's going to be called, and I assume since there's no agreement as to payment, potentially there's going to be an issue. So that's what I meant by he can't do anything until you get to the bottom of what she's going to be paid and whether she's willing to formally accept the case. Is that a fair statement?
Semi-fair. She is formally willing to accept the case. The issue is the hourly rate. JAC hasn't changed their hourly rate for this area of expertise for over 10 years.
So, Mr. Cacciatore, the request is to continue so that that issue can be resolved. Do you have any objection to that?
No, Your Honor.
All right. I'm going to grant the request to continue under the circumstances. What's the hearing date that we're currently working with, Mr.
I want to say September the 18th, Judge.
That sounds like what my JA told me as well. For control purposes, I'm going to set the case for my September 20th pretrial, October 2nd trial period, with the understanding that we can potentially address pretrial. And I understand that you're unlikely to tell me that you're ready to try this case on October 2nd, regardless of what happens to the 18th.
Correct.
But I just want to have the case scheduled close in time to the 18th so we can address them at the same time.
Thank you, Judge.
All right. That is the order of the court. Ms. Boone, you'll be returned to the Orange County Jail while Mr. Banquets continues to prepare your defense. All right?
Judge Boone.
Hold on one second. Ms. Boone, I've addressed pretrial. I've brought you over. I'm going to give you a moment if you want to share something else with me, but that's what I needed to address today, and I've got other matters that I need to address in short order. So.
I understand, and I'm grateful for your time. I had previously sent you a letter, and it has not been uploaded, but it was made an announcement to the courtroom during my pretrial that you do have it, and I was wondering why and if it will be uploaded, because I have another copy of it that I would like to hand deliver to you today.
I don't know why it has not been uploaded. I'll have to talk to my JA about that. If you want to give me another copy, that's fine.
Yes, please.
Go ahead and just tender it to one of the deputies. And actually, any objection if I just have the clerks scan it here in open court?
Yes, please. And do I normally get a copy? I haven't gotten one. I'm sorry.
Well, it'll be filed in the case.
If it's uploaded, Judge, I can make a copy and take it to him.
Okay. All right.
Yes, please. If that would be okay, I would like to have that one uploaded. It's revised.
Okay. And what I had directed my judicial assistant was to disclose this to the attorneys. Again, to a great extent, when I read the original, you've covered a great deal of ground that we've covered in open court on multiple occasions about the method and manner of communication. Having read the original letter, I did not believe there was any additional action that I needed to take, which is why I didn't take any action on that letter. All right? So to be filed, Ms. Boone will be returned to the Orange County Jail pending further order of the court.
Thank you.
You're welcome.
And with that, the hearing has concluded, the status hearing for Sarah Boone's case. Didn't we tell you? We thought there might be another continuance today. Lots and lots of delays. But this one makes sense. And this one, I'm sure she's not upset about because it benefits her. The defense team is looking to present a certain expert witness, and this has to do with that battered wife syndrome that we understand they're going to be presenting. And we're going to talk about that throughout the show this morning. But they're going to give her till September 20th. That's going to be a date where there's going to be another status hearing set. And then October 2nd, a second status hearing so that the case stays on track for trial, hopefully in the fall.
Let's go ahead and call up the Boone case.
State of Florida versus Sarah Boone, 2020 CF 2603. State.
Dave Cacciatore on behalf of the state.
Frank Bankowitz.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can I have JAC announce themselves as well?
Yes, Audrey Moore for JAC.
All right. So we have multiple matters scheduled this morning, one of which is Mr. Bankwitz's motion to withdraw. My reading of the law is I feel like I have to address that motion first and rule on that before I can address any other motions that would be heard today. So, Mr. Bankwitz, I'll start with you. Tell me why you're moving to withdraw.
Judge, the letters that have been coming to your honor, the derogatory berating of my services in this case, I can't effectively represent her. She doesn't trust me. She calls me a dud, I think, a buffoon, on and on and on and on. And no one should have to endure that type of derogatory comments and expect to effectively represent someone, especially in a murder case.
Ms. Boone, I read your letter dated August 26, 2023, and your letter dated August 30th, 2023. And just so we're clear, I read all of the letters that you send to the court. Whether I respond or not is based on what's in the letter and whether I'm asked to actually do something that's within my purview as a judge or not. If I understand correctly, you have now decided that you think it would be best, in fact, if Mr. Bankwitz was allowed to withdraw. Is that correct?
Yes.
All right. And you understand, by him withdrawing, I have to appoint another attorney. Do you understand that?
I do.
And that attorney is not standing here, so we're not going to be able to address, and I'll give the state a chance to talk to me as well, but assuming I grant this, we won't be able to address the other issues that were docketed for today, which means I'm going to have to reset your case for a later date. Do you understand that?
I'm not sure what items it is you're speaking of. I haven't received a copy yet of the letter.
So we're having a hearing today in regards to authorization for payment for an expert that your attorney believes he needs to defend you and issue about the compensation of that expert, which is why JAC is participating today. I don't know if your next lawyer is going to think that that expert's the right person to use, or whether they're going to go a different route after consulting with you. And even if they did, they're not standing here. And once Mr. Bankwitz is out, he's out. He can't argue the motion. So do you understand that?
I fully understand.
All right. Mr. Cacciatore, normally the state takes no position in these issues, but there are limited circumstances when the state doesn't take a position. So are you taking a position on this motion to withdraw, Mr. Cacciatore?
No, this would be one of those times where we would be not taking a position.
All right. So I'm going to grant Mr. Bankwitz's motion to withdraw. I'm going to appoint, let me find my list, Attorney Winston Hobson to represent Ms. Boone. In regards to the other matters scheduled today, I'm going to take no action on them at this time until Mr. Hobson can, well, in regards to the motion involving JAC, I'm simply going to take no action on that motion at this point in time until Mr. Hobson has a chance to review it and determine whether he wants to proceed with that motion. I will address the pretrial because today was also supposed to be pretrial. Here's what we'll do. Let me just get my calendar up.
There is electromagnetic energy in that pyramid between 200 and
As far as pretrial conference, I'm going to set this case for pretrial conference on Tuesday, November 28th, and a trial period starting Monday, December 11th. I think any earlier period of time would be unrealistic for Mr. Hobson to get on board, get up to speed with the discovery, and determine how he wants to proceed in regards to any experts. But I will set a status hearing on the case prior to that. I'll set a status hearing on the case Monday, October 30th, 2023 at 10 a.m. That'll be for the purpose of making sure that Mr. Hobson's on board, some sense of where he thinks things are, how realistic he thinks the November pretrial is, any other matters I need to address with him at that time. Now, Ms. Boone, in just a minute, they're going to take you back to the Orange County Jail. I'm going to suggest that you talk to Mr. Hobson about the various other issues you raised in your letter dated August 30th, 2023. One other thing I want to talk to you about, we had this conversation once in the past. Clearly, your working relationship with Mr. Bankwitz was such that it deteriorated to the point where the two of y'all just couldn't work together to defend your case. So I'm not going to try to referee how that played out, why that unfolded the way it did. But one thing I want to caution you about, if this becomes a problem on another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. You have a right to a court-appointed lawyer. There are certain decisions a defendant gets to make in the defense of their case that are absolutely theirs. Such judgment and experience, and look at the evidence, look at the law, and do the best they can. Also, you've got court-appointed counsel. As I've explained to you before, court-appointed counsel rarely have the luxury of representing one person and only having one case to focus on. I have concerns that your expectations of what any court-appointed counsel might do as far as spending time with you and the depth and degree of communication may be unrealistic expectations. You always have the right to retain a lawyer to represent you, and then that's between you and that lawyer. You can demand whatever expectations that you have as part of that agreement. But when it's a court-appointed lawyer, You have to accept and understand that they have other cases, other courtrooms, other responsibilities. And I'm cognizant of that when I'm addressing these types of issues about communication. So that's just food for thought, nothing to do today. I don't need a response from you. I just wanted to make sure you were aware of that and were thinking about that as we proceeded forward. So again, the court minutes reflect that court continuing pretrial. I have granted a motion to withdraw. I have appointed Mr. Hobson to represent the defendant, and I'm taking no action on the motion, the ex parte motion for cost directed where GAC is responding. Ms. Boone will be returned to the Orange County Jail pending disposition of her case.
Thank you, Judge.
All right.
I'm not able to say anything.
That's his information.
Another legal twist in the case against a woman accused of suffocating her boyfriend to death by zipping him up in a suitcase. As her trial was delayed yet again, Sarah Boone appeared in a Florida courtroom Monday with her new attorney. Her previous attorney had enough of his client and asked the judge to remove him from the case.
Judge, the letters that have been coming to Your Honor, the derogatory berating of my services in this case, I can't effectively represent her. She doesn't trust me. She calls me a dud, I think, a buffoon, on and on and on and on. And no one should have to endure that type of derogatory comments and expect to effectively represent someone, especially in a murder case.
In a letter written behind bars to Judge Wayne Wooten, Boone expressed her frustrations about her previous attorney, Frank Bankowitz, writing, quote, "So confused, so tired of the perpetual question marks over my head. It's funny how the only piece of correspondence via mail I've actually received from Bankowitz is his motion to withdraw as counsel. What is going on? I've tried to dilute some of the question marks, but need you, Judge Wooten, to help me get it correct and begin my preparation." But Boone's then defense attorney fired back in a motion to withdraw as counsel. Bankowitz wrote, quote, "Due to irreconcilable differences, he'll be unable to effectively and properly continue representing Boone," adding the defendant will not be satisfied with any attorney unless said attorney does not have a caseload, continuing the best possible avenue is to have the defendant represent herself, as no attorney can satisfy her. In September, the judge granted Bankowitz's motion to withdraw, appointing a public defender to take over her case.
Ms. Boone, I read your letter dated August 26, 2023, and your letter dated August 30th, 2023. And just so we're clear, I read all of the letters that you send to the court. Whether I respond or not is based on what's in the letter and whether I'm asked to actually do something that's within my purview as a judge or not. If I understand correct, now decided that you think it would be best, in fact, if Mr. Bankowitz was allowed to withdraw. Is that correct?
Yes.
All right. And you understand, by him withdrawing, I have to appoint another attorney. Do you understand that?
Yeah.
And that attorney's not standing here, so we're not going to be able to address, and I'll give the state a chance to talk to me as well, but assuming I grant this, we won't be able to address the other issues that were docketed for today, which means I'm going to have to reset your case for a later date. I'm going to grant Mr. Bankwitz's motion to withdraw. I'm going to appoint, let me find my list, Attorney Winston Hobson to represent Ms. Boone.
Defense attorney turnover rate has been high for Boone, who has cycled through more than 4 different lawyers since her 2020 arrest. In 2022, another attorney withdrew from representing Boone in her case. Boone claimed to be in the dark about her then attorney's withdrawal, writing in another letter to the judge. "After making a commitment to me as an attorney over the past 2 years and 2 months ongoing, to fully and sufficiently represent me also made me to believe we were a team," she wrote. "I am completely blindsided nonetheless in how this was and is being handled by a professional. I don't understand." The frequent occurrence even prompted the judge overseeing her trial to issue a stern warning, that the problem might not be the attorneys.
But one thing I want to caution you about, if this becomes a problem on another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. You have a right to a court-appointed lawyer. There are certain decisions a defendant gets to make in the defense of their case that are absolutely theirs, such as whether they go to trial or not, such as whether they testify or not. But there are many decisions in a case that a lawyer gets to make. And while you certainly have a right to consult with your lawyer and discuss with your lawyer, they don't automatically just do whatever you say. They use their professional judgment and experience and look at the evidence, look at the law, and do the best they can.
Sarah Boone has been behind bars since her arrest in February of 2020, charged with the heinous death of her boyfriend Jorge Torres. He was found lifeless inside a suitcase at the couple's apartment. The gruesome death was captured on video taken by Boone herself, showing the chilling final moments of Torres's life as he cried to be freed from inside the suitcase.
Sarah.
For everything you've done to me.
Sarah.
For everything you've done to me.
Sarah.
You.
Sarah.
You.
Sarah.
Stupid.
Sarah.
That's my name. Don't wear it up.
Sarah. I can't breathe, babe. Seriously.
Yeah, that's when you do when you choke me.
Sarah.
Investigators say the video showed the suitcase facing downward. However, a second video shows the suitcase in a different position, suggesting it had been moved.
Sarah.
Court records later reveal Boone and Torres were painting pictures and completing a puzzle while sharing wine when they decided to play a game of hide and seek. Boone would later tell police once they responded to the scene, she assumed Torres would be able to get out, so instead she went to bed, later finding him the next morning lifeless, still zipped up inside the suitcase.
I fell asleep, forgetting that he was in the suitcase.
So you guys were playing the hide and go seek?
Yes.
And at some point you put him in the suitcase?
No, he got in the suitcase. So he thought it would be funny to be put in the suitcase. So I was like, okay, well, I'm going to joke with you and I'll zip you up and make him, squirm a little bit, whatever it is.
Mm-hmm.
But then I fell asleep.
Mm-hmm.
I fell asleep.
Where was the suitcase?
Right where
it is.
In it.
Right down there?
Yes.
You zipped him in there?
Yes.
Thought he would be funny, a little joke?
It was. We both were laughing about it. Okay. And then I fell asleep.
Where did you fall asleep at?
Upstairs.
In your bedroom?
Yes.
Okay.
Totally forgetting that he was in the suitcase still.
Okay. And then you came back downstairs?
This morning, or this afternoon, yes, when I got up.
What time?
12:30-ish. I was awake, but I totally forgot that he was in the suitcase.
But that fatal alleged mistake would end up with Boone's boyfriend dead and the suspected killer behind bars. During Boone's police interrogation, she denied zipping the suitcase entirely, despite video evidence showing investigators the opposite.
Also in the video, you can't see any holes. There's nowhere in that where the zipper separates and you can see a hole. If there's a hole, he's pushing on it, begging you to get out. We should probably see that hole.
He essentially would have been able to get out.
Yeah.
Alcohol. Based off what you're telling us, he should have been able to get out.
Okay.
But the video shows him attempting to get out, begging to get out, and he can't. So that's just what we're trying to figure out. I don't know if maybe you had too much to drink, you zipped it up all the way, and then,
I did not zip it up all the way.
Okay, well.
I did not zip it up all the way. This is horrific, okay? Horrific.
It is terrible.
Yeah,
horrific. I don't think I'll ever be right because of this. Ever be right. I didn't mean to leave him there. That's what I'm trying to tell you.
You got up and walked away. How is that not intentionally leaving him there?
Because I'm looking at the hole knowing that it's there. He'll get out no problem. Because you don't.
And then he doesn't. But you don't go check on him. You say you're up for 30 minutes and he doesn't come up. You don't go down and check on him?
I'm in the bed.
You even moved.
And dozed off.
You admit to moving the suitcase like over. So
You roll it.
You roll it over. Like it's not like
I didn't want it to be like that. Don't.
you didn't want him to be upside down. How do you even get upside down?
Right. You guys are killing me right now.
According to an autopsy report, the medical examiner noted multiple injuries to Torres's body. He had long nail scratches on his back and neck, contusions on his shoulder, skull, and forehead, considered as blunt force trauma. Boone has maintained to police she did not mean for Torres to die.
I promise you, on my son's life, it was not intentional. I promise you, on Lucas's life, it was not intentional.
I don't know you. I can't say I know anything about you. I don't know what would be a true statement, what would not. I mean, you're promising on your son's life, that's fine.
That's how much it means.
Sorry.
That's how much that's how much it means.
Okay.
I hope you take that to heart.
She was ultimately charged with second-degree murder in Torres's death. She continues to be held without bond, and if convicted in trial, faces the rest of her life in prison. Boone was initially set to head to trial earlier this month, but with the constant changes of counsel, her trial kept getting pushed back. During Monday's hearing, the judge set a January date for the pretrial conference, where the defense will be expected to set Boone's new trial date. Reporting for Law and Crime Network, I'm Elizabeth Miller.
State of Florida versus Sarah Boone, 2020 CF 2603. State.
Dave Cacciatore on behalf of the state.
Okay. Mr. Cacciatore, good morning. The court was just made aware that a motion to continue waiver of presence was filed on January 12th, 2024 at 11:18 a.m. A copy of it was not favored to my office. My judicial assistant found it this morning by scouring the record once we did a call in the halls for counsel for Ms. Boone. The motion reflects that additional time is needed in order to prepare this case for trial. Counsel is still reviewing extensive discovery in this case and is also seeking appointment of experts with the S in parentheses. This court has approved costs for a private investigator. The task to be accomplished in preparation for trial cannot be concluded by the now scheduled trial date. Reflects that speedy's been waived and that you had no objection to same. Is that accurate with regard to your objection or lack thereof?
That is, and I've had the chance to review that motion, Your Honor.
I'm sorry, Mr. Cacciatore, say again, sir?
That is accurate, and I have reviewed defense's motion to continue.
Okay. The motion does not identify the amount of time that they're seeking a continuance. In your conversation with Counsel Hobson, are you in a position to advise the court as to how long of a continuance they're seeking? Oh, no, the wherefore clause says 3 dockets. I apologize. Any objection to that, sir?
No, Your Honor.
Okay. The motion to continue will be granted. This matter will be continued for 3 dockets. Now, my understanding is that this is typically specially set. So do we want to have this especially set at a certain time, Mr. Cacciatore?
I think that would probably be better. Typically, Ms. Boone is elected to attend many of these hearings and not waive her appearance at them. So I also think too that we're at the point that we're close to being I think ready for trial, and that I guess without getting into too much more without Mr. Hobson here, yes, I think just we could set it for a special set status.
All right, the court has availability for a special set on May the 3rd at 9 a.m. The court's inclined to have this as a special or as a final continuance due to the age of the case and the motion not specifying anything more than a 3 docket continuance.
That's acceptable.
Okay, all right, we'll set this matter for a special pretrial on May the 3rd at 9 a.m.
Ms. Boone will have a mandatory appearance for Ms. Boone at the May 3rd at 9 a.m. pretrial. What's the following trial period for that?
The trial period for May the 3rd would be May 13th.
All right, with a trial period of May the 13th.
Thank you, Your Honor.
All right, thank you, sir.
Let's face it, I do not believe it's the previous 7 lawyers, and I really don't believe it's Ms. Cashman. It is the client.
Accused murderer Sarah Boone is at it again, just months before her highly anticipated murder case is set to be tried. Her defense attorney motions to withdraw from the case.
Well, it's her. Obviously it's her and not the attorneys.
For those keeping score, that's the 8th attorney to want off the case.
When I see 2, 3, or 4, difficult. When I see 8, it's almost playing the system. She's just acting in a system obnoxious kind of way.
Plus, there are the many letters Boone has written to the judge since her arrest.
I think it's not only unusual, it's extraordinarily dangerous.
We sit down with expert defense attorney Marco Mara to discuss the case so far and what he expects moving forward.
I think this judge is going to say, you have 2 choices, pick one. Ms. Cashman is your lawyer and will stay your lawyer through trial, or Ms. Cashman will be your advisor and you're trying the case yourself. I think this judge is not kidding. He's not going to be delaying this case very much more. I would plan on popcorn in October because it's going to be a trial to watch.
The case of Sarah Boone has captivated the nation for more than 4 years now, with multiple trial dates set and postponed, attorneys hired and withdrawn, and a handful of strongly worded letters penned by the defendant herself. But before all this, there was a murder allegedly carried out at the hands of Sarah Boone herself.
For everything you've done to me.
Sarah.
For everything you've done to me.
Sarah.
Thank you.
This now famous video was recorded by Boone in February 2020. It shows Boone recording and laughing at her boyfriend, 42-year-old Jorge Torres, who's been locked inside a suitcase. Later, investigators would be called to their Winter Park, Florida home, where Torres was found dead inside the luggage.
Cute.
Sarah.
Stupid.
Sarah.
That's my name. Don't wear it up.
Boone told investigators she and Torres had been drinking and playing a game of hide and seek. Boone says she forgot about Torres inside that suitcase and then went to sleep. She says she awoke hours later when her phone rang, and that's when she says she found Torres unresponsive.
My plan was not to go upstairs and go to sleep.
Well, that's what you did.
Yeah.
But not intentional though.
No, you told me you went upstairs because you were
Stop
getting
here.
ready for bed.
Stopped here.
Okay, but
Where's here?
Initially, Boone called her ex-husband, and he was the one who told her to call 911. Investigators arrived on the scene to find Torres dead with a cut on his lip and bruising around his eye. They later determined Torres had been inside the suitcase for hours and likely tried to escape.
But why is he saying I can't breathe, and why is he pushing on it as if he can't get out?
And it doesn't show a hole.
There's no hole. There's no fingers. I don't see his fingers. There's no hole.
I don't know what you want me to tell you. I don't know.
Boone was eventually arrested and charged with second-degree murder. Right now, she's still being held in the Orange County Jail. Law and Crime has followed the story since it broke and reported on the multiple trial dates set. They've repeatedly been delayed or rescheduled due to the seemingly revolving door of attorneys hired and then appointed to represent Boone. Just last week, Boone appeared in court with her attorney Patricia Cashman, but only a few days later, Cashman filed a motion to withdraw herself from the case. She's now on her 8th attorney, and this attorney just filed to withdraw from the case. So just from the offset, with 8 attorneys, what are you thinking hearing that number?
Well, it's her. Obviously it's her and not the attorneys. I mean, I've handled, obviously, thousands of cases. And look, there's often conflict with some clients, mainly because you might be telling them something they don't want to hear. But we don't take our cases personally like a doctor. I mean, if doctors deal with blood, we deal with crime. but we know what we're doing. But someone like Miss Boone, I think she's just, if you're not in lock sync with her, then you're the problem. Now, you tell a doctor where to cut on your body and they tell you to shut up because they know what they're doing. So that's when I see 2, 3, or 4, difficult. When I see 8, it's almost playing the system.
Marco Mara is probably best known for representing George Zimmerman, the man who was acquitted in the death of Trayvon Martin in 2012. He's very familiar with the Florida legal system and suggests that the problem is Boone rather than her attorneys. Are you at all surprised that she's yet again having issues?
Well, with her history of going after every lawyer she's had so far, it's almost, and I don't want to presume more, but when I look at a case like this, and we're demanded to give some ideas or insight, she's either just horribly obnoxious and doesn't want to go to trial and thinks this is a way to delay. That's not going to last long because this judge is not going to allow her to just keep moving a lawyer to lawyer. Or maybe she has some underlying mental health concerns that don't allow her to understand and to act within the appropriate process that we all are bound by.
During a hearing on June 7th, Boone's current attorney Patricia Cashman told Judge Michael Kranick that Boone had walked out of their meetings, making her difficult to represent. Cashman motioned to withdraw from the case on June 11th. The motion reads in part, quote, "A lawyer must not represent the client if there is a substantial risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer." Cashman goes on to note irreconcilable differences. She noted irreconcilable differences. And for me, I hear that oftentimes when it's related to divorce. How would that work in terms of a client and attorney relationship?
So, and that's the precise reason why she used those terms. Look, I represented somebody who was charged with killing between 7 and 11 women up and down the I-4 corridor. So Orange County's first sort of official, one of their first official serial killers. And he didn't speak to me for like 5 months because he thought I was part of the problem. But you can still do your job, right? I can still get the work done. We actually tried that case in front of a jury. But the irreconcilable differences are when you say, we should do this as the professional, like a doctor, you need this surgery, and they say, no, I know what I'm doing better than you. And unfortunately, at a certain point, you can't do your job because you have dual loyalties. You have an undeniable loyalty to your client, but you also have a loyalty to the law and to the system that you can't, obviously you can't lie to a judge. You can't have a lack of candor to the judge. You can't compromise your own ethics on behalf of a client. And it sounds as though, and I know Ms. Cashman, she's a great lawyer, and it seems as though she was put in a position where the client will not allow her to do what she knows she needs to do, so she has to move on.
In that same motion to withdraw, Cashman said that she had ethical considerations. Differences there, what could that mean?
And those ethical considerations are, I want you to do this, and it's unethical. I want you to argue this, and we know the law doesn't support that argument, then you can't do it. Now, if the law allows you to argue for an extension of the law, right? It applies in this case. It may not yet apply in my case, but I can argue it should. That's all ethical good behavior. But if she is telling her to attack this witness about this issue, which is completely non-relevant, then yes, those are the ethical issues that arise where they tell you to do something as a lawyer that your ethical code says you cannot do.
Meanwhile, Boone straight up called her attorney snotty and alleged Cashman lied to her. Boone also wrote upwards of 50 pages worth of jailhouse letters to the judge saying Cashman isn't measuring up as a defense attorney. But that's not the first time we've reported on Boone's handwritten letters to the case's judge. Is that something we normally see, the communication between her from jail with the judge?
No, and there really shouldn't be, because she is sort of, in one sense, I don't want to say sealing her own fate, but look, one constitutional right that every criminal client has available to them is to not help the state convict you, right? You have the right to remain silent, not only because of Miranda versus Arizona, but way back when in the beginning, the Constitution says they can't make you testify against yourself. And even those words are not testimony in a courtroom, they are admissible. The state has them, and the state can sit back in some remorse argument or lack of remorse argument, or if she says something inconsistent, then they can use that as an impeachment. So no, I think it's not only unusual, it's extraordinarily dangerous.
I'm also wondering, as she heads to trial, if that ever does happen, could these letters be brought in, or the fact that she's gone through so many attorneys, would that be relevant at all in front of a jury?
The fact that she had so many lawyers, no. I don't think that would be relevant. And there's this one filter that we have, that the evidence that comes into court, the benefit of it has to outweigh the prejudice of it, right? So if I have a Schwartz sticker on my forehead and it's covered over for trial, that was so prejudicial that it would never come into evidence. Unless they were saying I was part of a Nazi gang or whatever, then it's relevant, right? So you have to do that balancing. In a case like this, they would never be able to say she can't even get along with 7 lawyers. It does become relevant sometimes with what she said in those letters and whatnot. And if she were to argue in front of the jury, it's all my lawyer's fault, maybe, but probably still not, but maybe that would open the door for the prosecutor to go, it's not just this lawyer, she's done this 7 times before.
O'Mara says it appears that Boone is hoping to delay her trial, but the motivation doesn't exactly add up. Let's say that Sarah Boone's motivation in all of this, going through these many attorneys, is that she does want to delay her jury trial. Why would that be? She's just sitting in jail during all of this time anyway. What do you think is going on in her mind?
I think in her mind, again, if I was to sort of open up and say, here's my magic wand, what I think, she has to if she was out, then the idea of delaying a trial at least has some benefit. You stay out. The other harsh reality is if you're going to have a trial and may get convicted, you may want to go ahead and get your time started because you don't get out until you finish your sentence. So another counterbalance to delaying things. It seems to me, from my review of the media and knowing the case a little bit, she's just acting in a system obnoxious kind of way. Like, I am not going to give in. If she doesn't come out and see me 8 hours a day, every day, she's not being a good lawyer. Problem with it is that our standards, even as lawyers, for competency, we have to be competent at what we do. But no, I don't sit at the jail every day with every client. It wouldn't work. And I don't need to. Like, a doctor doesn't need to sit with you at lunch at home to see if you're eating healthy. No, he tells you to eat healthy, goes on to the next patient because she, as a doctor, knows what they're doing.
This is a Kizik shoe. It's a hands-free shoe that you just slip right on and stays on. After years of development,
they're doing. Lawyers know how to be efficient, knows what's relevant and what gets in and what gets out and what needs to be focused on to benefit the client. And she doesn't seem to know nor care as to good, efficient work by a lawyer.
O'Mara says there could be some underlying mental health issue for Boone, meaning she could potentially be deemed incompetent to stand trial, but it's not super likely.
The analysis for incompetency to stand trial is sort of a low bar. So you have to know what a lawyer is. You have to know what a judge is. You have to know that you're being charged with a crime. You have to know that you could go to jail if you get convicted. It's a very low bar to be able to say, yes, I'm competent. Now, there are people out there who cannot sit for trial because they're incompetent. They cannot understand the process. And one other element is, are they aware enough to assist the attorney in their own defense? And that's an interesting one here. But again, you can't just refuse. You have to be cognitively unable to. And I don't think then she'll ever get to the point of legal incompetence in a case like this. She seems to know exactly what she's doing. Matter of fact, that's the problem with some of those letters to the judge, is that she makes, I'm not saying she's right in what she's saying about the lawyers, but she makes sense in saying it. And that means she's, sort of verbally competent.
For now, Boone is considered competent to stand trial, and that's expected to begin this fall. This trial is set for October, and if she was to move on to her 9th attorney, how would it even be possible for them to prepare all of this in time, their discovery, go through everything in time for October? I mean, would that even add up?
It could. I mean, if the judge called me up and said, you got to try this case in October, my questions would be, are the depositions done? Yes, they are. All the discovery out? Yes, they are. Medical records done? Autopsy done? Yes. Videos, body cams? Yes. All the discovery is done. So while that's a tight timeline, if you told me to do it in July, I would say just can't do it. I don't care how many records are out there. It takes time to go through them. But October is far enough off that a good qualified lawyer like Ms. Cashman or me can look at a case and get it ready. Again, we do this a lot. It's like a surgery. Yes, you have to be careful of the blood work and you have to be careful of the x-rays and all that. But we know the confines within which we work pretty well.
If you are interested in our future coverage of this story, be sure to subscribe and ring the notification bell before you go. Verdict Vantage thanks you for supporting our continued news coverage and research.
Thank you for tuning in. Stay tuned for more breaking stories, and remember, email verdictvantage@gmail.com with all of your video requests.